And they got to choose, okay, we'll file that company in Corpus Christi, and by virtue of having one company file in Corpus Christi, everybody got to file there. So that's how they picked it, and it's not illegal what they did. Having said that, the management gets to pick, but creditors can object, and other people can object and say, no, we think you picked it for a bad reason, or maybe you picked it for good reasons, but it's not convenient. We'd like you to move it. And here, the creditors have said, really, that Scotia Development Company that's in Corpus Christi really is not central to the dispute. What's central to the dispute is reorganizing this timber company. And that's in California. And this case really should be in California. And the creditors committee has said, and what's the judge consider when he considers that request? He looks at where the assets are, he looks at where the creditors are, he looks at where management operates out of, and he tries to figure out which is most convenient for all parties involved. Here, the committee, the state of California, and various regulatory agencies have asked him to move the case to California. The creditors committee has asked him to move the case to California, and he's going to decide that, I understand, he's going to decide that on Tuesday, this coming Tuesday, or at least there's a hearing on it, and he may decide it on Tuesday, or he may say, I can't decide, I'll have another hearing. This is important for a number of reasons. But one is, if you're a small, one of the things that happens in bankruptcy court is all of the debtors' disputes are resolved in that court. So that's one reason. If you were a company that was being sued, if you were a company that made a bad automobile part that was installed in 1 million automobiles and it caused 1 million accidents all over the country, you were being sued in 50 states, you might say, okay, to heck with that, I'm filing for bankruptcy, and I can centralize all these disputes in one forum, because bankruptcy court allows all disputes to be carried out in that one forum. If you're a creditor and Palco or Scotia owe you money, or you claim that they owe you money, and they dispute it, that dispute will be resolved in the bankruptcy court. Right now, that's Corpus Christi. So if there's no dispute, it doesn't matter. You'll get paid whatever you're going to get paid at the end of the day. But if you have a dispute with Palco as to how much they owe you, or what the interest rate is, or whether some of it's pre and some of it's post-petition, or whether it's entitled to any particular priority under the bankruptcy code, that dispute will be resolved in Texas. So in that sense, for smaller creditors, you might rather than to be closer to home. But again, if there's no dispute, it wouldn't make any difference. This, I have the list of participants here, and there's really, these are the participants in every case. But here we have an unusual situation where the state of California and its regulatory agencies are playing a bigger role than usual. That's unusual, and I think that's arguably that's one reason that Texas is an attractive venue for Palco, because they may feel that the California courts are more likely to defer to the state regulatory agencies than a Texas court would be. But that level of participation is unusual, and it's something that makes this case distinctive. That's the end of my first half of my presentation, and I thought I had 30 minutes of material, and I don't. But if you have any questions, or if there's something that I haven't covered, please get a card, write down your note. We got a couple.
Yeah, we got 2 so far.
Has Charles Hurwitz used bankruptcy as a business strategy before? That's an excellent question, and I don't know the answer. I'm sorry. Has Charles Hurwitz used bankruptcy as a business strategy before?
Kaiser Aluminum.
Kaiser Aluminum.
And the Simplicity Pattern Company.
Well, I didn't know the answer, but I've suddenly been given a newsflash that the Kaiser Aluminum and Simplicity Patterns cases. This, in some respects, this case is not as unusual as, in some cases, in some ways, this case is an ordinary case, and I'll show you how. Thank you. And I thought of this because of the reference to Horowitz. But there was a million of these companies in the 80s and the 90s who engaged in things called LBOs. An LBO is a leveraged buyout. And it means that, and just like when you buy your house, you can't pay cash for the whole house. You gotta borrow from a bank, and the bank takes a mortgage on the house. Similarly, when Charles Horowitz, or whoever, I don't mean to single him out, when he buys Palco and Skopak, who's got 800 million bucks? Not him. And if he did, I'd rather not put it all down. I'd rather make a small down payment and borrow the rest. And he borrowed the rest. I think it was over 8 when he did it. Now it's down to 716, still a healthy amount. And it's borrowed by it's borrowed by Palco and Skopak. And as long as he can make the payments, there's no problem. But if he can't, and as long as you can make the payments, there's no problem. Who cares? But if you can't make the payments, then who gets hurt? All of these, all the employees and the other people, other creditors. Because if you look at it, the day before, here's this little happy company, Palco Skopak, which owes, Jones Widgets $50. And Mr. Jones is pretty sure he's going to get paid because it's a great big Palco Skopak and they owe me $50. I'll get paid. The next day, Jones is still owed the $50. But the same company owes somebody else $716 million. At this point, Jones is nervous. And they didn't get anything for incurring that debt. All they got was a new owner. That's how a leveraged buyout works. There was hundreds of them in the 80s. And Horowitz probably did more than this. Lots of people did them. Some of them were successful, some weren't. But a lot of them had to be fixed in bankruptcy. And we'll talk about this in the second part. But what happens is you have a company that turns out to be worth X dollars, and it has debt, which a very optimistic purchaser put on it in an LBO of 2X dollars. I'm just making that up. I have no idea what the numbers are here. You've got to fix this problem. Company can't operate profitably. You've got to fix this problem. It's a great company. Before the debt, it made money. Before the debt, it could operate its business, pay its employees, make a profit, deliver dividends to shareholders. But with this level of debt, it can't do it. So bankruptcy and Chapter 11 bankruptcy is getting rid of that debt. That's what we'll talk about in the second part. Am I
There
gonna?
are a couple, here, right here, there's 3 questions you could answer.
Have the note holders requested a change of venue? My understanding is that they are going to file a paper tomorrow, Monday. I don't believe that they have formally requested that yet, but they have certainly, they've filed papers suggesting they are sympathetic to the requests of the creditors in the state of California. So they haven't decided. Read the paper on Monday or Tuesday, and you'll see whether or not they join the motion of the state and the creditors committee. Can Palco file for Chapter 7 in the future? Yes. Most Chapter 11 cases, this is depressing news, most Chapter 11 cases are failures. But that's, and it's true. Most Chapter 11 cases ultimately convert to Chapter